चीफ जस्टिस पाकिस्तान जस्टिस आसिफ खोसा आईजी ऑफिस में पुलिस अफसरान से खिताब कर रहे हैं।
Has really shown us the way, and we are ever so grateful to them for their time, for their effort, and for their input. The other members of the police force who have gathered here from all over the province of Punjab, respectable media persons, families of the Shohada, distinguished guests, ladies and gentlemen. My association with the police dates back to the year 1976, when I was a student and my eldest brother, Mr. Tariq Khosa, joined the Punjab Police. And as he progressed in his profession in the police department, we also had greater and greater involvement through him, till such time that in the year 1989, I had a direct interaction with the police when I was invited to speak to the under-training officers at the National Police Academy, Islamabad. And that was a year when I didn't know that after so many years, this year will come back to me. And I recall that some of the under-training officers in that 1989 batch, and I had the privilege to address them on that occasion, they are now the senior-most police officers in the entire country, and some of them are inspectors general in different provinces, and some of them are present in this ceremony today. My third interaction with police has been throughout my career as a lawyer and my career as a judge. I had been dealing with criminal cases most of the times, and in every criminal case, it's the working of the police which comes in issue, and then you start developing an insight, not only as how police works, but what are the pitfalls in the working of the police, which are the areas which need improvement. And then I was very fortunate when I came to this office, to this job, then a police reforms committee had already been constituted by my very honorable predecessor, Mr. Justice Mian Saqib Nisar, the then Honorable Chief Justice of Pakistan. So I inherited this position as the chairman of the Police Reforms Committee. But immediately after coming into this office, we got going with the help of the retired Inspectors General and the serving Inspectors General. And ever since, we have remained quite busy, and we have launched a number of initiatives. As the Chief Justice, I have launched many initiatives, not only in the police department, but in the information technology, as far as the Supreme Court and High Courts are concerned. Then we have launched model courts for expeditious delivery of justice in criminal cases. We have also established gender-based violence courts. And I'll focus mainly today on whatever we have been trying to do in the police department and in the criminal justice sector from that angle. But before I come to that, I want to share with you that my first priority when I became the Chief Justice was to restore dignity of all those who appear before courts. Not only the litigants, but also the officers of different departments, and particularly the officers belonging to the police department. As a judge of the High Court and then as a judge of the Supreme Court, I had personally witnessed some incidents in which officials coming to the courts at different times, I'm not blaming anybody, but this was the prevalent practice, that somehow the officials appearing before the courts were not treated with that much dignity as they deserved. And sometimes the situation was absolutely unbearable. And hats off to the members of the police who belong to a disciplined force. They never responded. They just bore with it. They just lived with it and kept on showing respect and dignity to the court, and as was expected. So my first priority was that we should ensure that a court works as a court, and anybody appearing before the court, and particularly members of a disciplined force, once they appear, they should be afforded due dignity and respect, whatever be the nature of the case, whatever be the circumstances of a case. The dignity, which is a fundamental right under Article 14 of the Constitution, cannot be violated. The Constitution says dignity of man is inviolable. And I'm going to share something with you which so far nobody knows except the Supreme Judicial Council, that one very senior judge of the High Court was proceeded by the Supreme Judicial Council only on the allegation that he had humiliated and insulted a police official in the court proceedings. So that was a message that we sent straight away, that everybody is to be entitled to dignity, and whatever be his calling, whatever be his job, once he appears in the court, he is to be accorded due respect and treated with dignity. That we have already achieved to greater extent, and incidents of officers being treated rashly or not properly have reduced to a great extent, and we are still looking into it, that no such incident takes place at all, not just with police officers, but with anybody who appears in a court of law or anywhere else. As far as the Police Reforms Committee is concerned, I'll also, before that, I'll tell you another thing, that ever since I became the Chief Justice, whenever something happened in the country which took notice of the public at large, there was an outcry that the Chief Justice should take suo motu notice. I realized that because of the activism of some of my very respectable seniors, the departments themselves were already on toes, and whenever any incident took place, immediately all the concerned officials would reach the spot, respond to the situation, take the matter into hands. And this is what the court was expected to do, even if a notice had been taken by the court, that those officials, those departments were to be activated by the court, but the real work was to be done by the court, by those officials themselves. So if the officials are already efficient, if they are already doing their job, if they are already attending to an emerging situation, then there was no need for the court to jump in. There were times when an incident would take place in the evening. During night time, a notice was taken by the court, and in the morning, all the senior officers would be running to Islamabad to appear before the Supreme Court, rather than going to the place of occurrence and attending to the situation that had been created. So that, I thought, was not correct. And if the officials are not responding, if the situation is not being tackled, then somebody has to nudge them, somebody had to activate them. Yes, in such a situation, it could be justified that the court intervenes. But now that whenever any incident takes place, all the senior officers everywhere in every concerned department are active, even in matters relating to police. The IGs, the DIGs, and everybody is active, and the political administration executive also intervenes, and they are active. So there was hardly any need for the Supreme Court to jump in at a premature stage, particularly when the Supreme Court is a court of last resort. How can it afford to become the court of first resort, an institution of first resort? Now something had to ripen up, something has to mature, then investigation is to take place, trial is to take place, appeal is to take place, and then the matter will come to the Supreme Court. And if we interfere on day one, then the whole process of justice will be retarded. That will be reversed, and that's never conducive to the interests of justice. I have seen some cases, I've handled some cases in which many years ago some notices were taken on some incidents, and it was declared at that time by the Supreme Court that this is a case of terrorism and an FIR should be registered and trial should take place on the basis of such a declaration by the Supreme Court. Later on it transpired that the case was merely a case of private enmity or a private grievance. So it was argued before us when the matter came up in appeal that this is not a case of terrorism, and our hands were tied. We could not say that it's not a case of terrorism because a judgment had already been rendered right after the incident by the Supreme Court that yes, it is a case of terrorism. So such premature intervention, I was of the opinion that it is ill-advised. So as far as I am concerned, I have exercised restraint in the matter and have not bothered any other department so far if the department itself is already actively engaged in the matter. Now coming to the Police Reforms Committee, we have launched many initiatives, but the most important, which affects the population at large, is the police complaints mechanism, and the SP complaints were installed in every district throughout the country, and I'm so grateful to the Inspectors General who have fully cooperated and have spared an SP in every district to attend to the people's grievances straight away before people have to have resort to a court of law for redressal of their grievance. In this respect, the results are absolutely unbelievable. People immediately took a liking for this new forum that we had created. People didn't have to go to court. People didn't have to spend money on resolution of their grievance. And then I'm told the figures given to us only a few hours ago in the Police Reforms Committee meeting was that so far 1,20,000 complaints have already been attended to by the SP complaints. And out of those complaints, about 95% of the people have gone satisfied, and they didn't go to any court for redressal of their grievances, with the net result that within these few months, 100,000 more cases would have been added to the courts, which did not come to the courts because the grievance was redressed at another forum and the appropriate forum. So this is one great success and serving the people in a befitting manner, that within the police department itself there is a mechanism for redressal of grievances, and only those who are dissatisfied with such a recourse, then they can go to the court and the court can attend to their grievance. The other thing which is worth mentioning in this context is that in the high courts, 15% lesser number of writ petitions have been filed in the high courts throughout the country. And in the district judiciary, 30% lesser number of complaints or petitions filed before the district judiciary against the police within this short span of time. Now 15% or 30% is a huge number when you consider that we are talking about population of 22 crores. Then 30% reduction in the high courts is in the district judiciary is phenomenal figure, and we are so proud that our police has responded to the necessity, reducing the burden on the courts, and the courts had more time to attend to those real issues which deserve to be attended by the courts.
चीफ जस्टिस पाकिस्तान जस्टिस आसिफ सईद खोसा पुलिस अफसरान से खिताब कर रहे हैं और उनका कहना है कि बतौर चीफ जस्टिस पुलिस, अदलिया और IT में इस्लाहात की हैं और चीफ जस्टिस का ये भी कहना है कि जब भी कोई वाक़या रूनुमा होता है तो उसके बाद अदालतों को ही फैसला करना होता है। बेहतर ये है कि बेहतर प्रोसीडिंग करते हुए और हक़ के मुताबिक फ़ैसले किए जाएँ। जबकि साबिक़ चीफ जस्टिस साकिब निसार ने पुलिस इस्लाहात कमेटी तश्कील दी। चीफ जस्टिस पाकिस्तान ने कहा कि अदालतों में पेश आने वाले ऐसे पॉलिटिकल वाक़यात जिनके लिए प्रोसीडिंग्स बहुत ज़रूरी होती हैं, उनको मेरिट पर प्रोसीड करना बहुत ज़रूरी है। जबकि बतौर चीफ जस्टिस पुलिस, अदलिया और IT में इस्लाहात की हैं। चीफ जस्टिस पाकिस्तान का ये कहना है।
Some other officers belonging to the police, and they would assess every month as to why in so many cases in that district anybody was acquitted. There must be a reason mentioned in the judgment, and why bails were granted in some cases where the prosecution thought that those cases were not fit for bail. The result of deliberations of the District Assessment Committee would be then presented to the local police heads, whoever they are, and then the results of deliberations of that committee would trickle down or be conveyed to the investigating officers, so that in future cases the investigating officers do not repeat the same mistake. So this mechanism is already in place. It has started showing results, and in the last meeting of the Police Reforms Committee, the Inspector General of Police Islamabad had informed us that the crime rate has already started coming down. So this is the result, that previous mistakes are not repeated, and for future purposes the investigations are conducted on the lines which are acceptable to the courts. The evidence is produced in the court which is acceptable, not rejected out of hand, because the investigating officer did not even know what mistakes he was committing. So he would be made aware of the mistakes being committed by him, and next time he would be expected not to commit those mistakes. So this again is a very positive development, and it will lead to more convictions in future, and we hope that this experiment will be expanded throughout the country, which it has started in the country, and it will be expanded in due course. The third aspect in which the police has been of great help is establishment of model courts. We have established model courts in every district of the country, and initially they started trials of murder cases and narcotics cases. And again, the results are absolutely unbelievable. Only because the police has been cooperating with us so much. The main things that we did in the model courts was, it's the same judges, same lawyers, same courtrooms, same law, same procedure. Only through some administrative measures we have fine-tuned the system and eliminated all possibilities of an adjournment of a case. Now, the first and foremost reason for adjournment was that even in a state case, even in a challan case, it was the complainant who would bring his witnesses. And on one date of hearing, the complainant would say, I've been able to bring 2 witnesses. On the next date of hearing, he would say, none has come with me. They're busy reaping their harvest, or they're busy irrigating their lands, or somebody was ill and he couldn't bring. He didn't have any influence on his witnesses. So the first major thing that we emphasized vis-a-vis the police's role in this respect was that we said, no, in a state case, it is the responsibility of the state to produce witnesses. So the inspectors general, and we're so grateful to them, they undertook this. Focal persons were appointed in every district, that the court would tell the focal persons that so-and-so and so-and-so, son of so-and-so, resident of so-and-so, is to be produced before the court on such and such date. He is a prosecution witness. It is the police now which brings those people, and as you can imagine, nobody can say no to the police. So every witness is present, and there is no adjournment. The other things that we did may not be relevant to you, but very briefly I would say that instead of a rollover system, that the court is dealing with 50 cases at the same time, and every day there is a list of 15 or 20 cases in which the trial court has to make some progress. So he would record one witness's statement in one case, adjourn it to another month, and then take up another case, record 2 witnesses in the other case, decide a bail application, decide a transfer application, and some miscellaneous work, and then the cases would roll on together. We changed that. We said no, only one case at a time. And once the case starts, the next case will be taken up when this case finishes. So a scheduling of case is undertaken by the judges, the lawyers of both the sides, as well as the prosecution and the police representative. They are present. Within their presence, it is decided that on such and such dates the witnesses will be produced. On such and such date the accused will be given a chance to rebut them. On such and such date the arguments will be heard and decision shall be announced on that date. And this is meticulously being adhered to.
चीफ जस्टिस पाकिस्तान जस्टिस आसिफ आईजी ऑफिस में पुलिस अफसरान से खिताब कर रहे थे और उनका भी यही कहना था कि रिटायर्ड पुलिस अफसरान ने भी पुलिस इस्लाहत कमेटी में अहम किरदार अदा किया है।